Hey guys, Kyla at the MJC again, and this time I'm here to talk to you guys about the equalization of marital property, the taxes, and the legal name restoration sections on the proposed marital settlement. Before we get into that though, as always, I just want to remind you that nothing in this video is intended to be legal advice. It's a video, so it means I'm not able to analyze your specific situation to determine whether this is the right set of forms for you, whether what you're asking for is likely to be approved by a court, or whether you're asking for what's in your best interest in your circumstances. So if you have questions about any of those things, I would definitely recommend some legal advice. You can get legal advice for free through the Marquette Volunteer Legal Clinics, which are located in the MJC is in room G9. I messed up my little spiel there, but I hope you'll all forgive me. For those of you who are not located in Milwaukee County, you can contact your clerk of court to find out what resources are available in your county. All right, so on with the equalization section here. So equalization of marital property is basically a fancy way of saying you have now proposed how you and the other person in your case are going to divide all of your property, all of your assets, all of your debts. If you think that one person got a lot more than the other person, you can say that the person who got more has to pay the person who got less to make it equal. If you don't want to mess with that because you are happy enough with your proposal, you can say no payment is required because it has been equalized to the satisfaction of the parties. Fancy lawyer language for we are happy enough, or I am happy enough with this proposal, because obviously since this is a proposal, you don't know if the other person's happy. But saying basically, I think the proposal is fair enough, I'm happy. The other option is you might say there's no payment because there was some real estate that was sold and the proceeds were divided. So if that's the case, you'll select B. So that's what most people pick. However, if you think that you would like an equalization payment, you think that your stuff was divided in a way that wasn't fair, one person got more than the other, you can say that a payment is required and you'll put how much you think that payment should be. So here I'm just picking a random number. We'll say Jane thinks that there should be a payment of $2,000 to make the division of property fair. Sometimes this is used if, John got to keep all the stuff. He's keeping the house and all the cars, and Jane's saying, that's fine, you can keep the stuff, but you should pay me, half of what it's worth. But anyway, so they think there needs to be a payment. Here we're going to say who is going to make the payment. So we can either say petitioner or joint petitioner A will pay respondent, joint petitioner B. So in our situation, that would be Jane would pay John. Or we can say the respondent / joint petitioner B is going to pay the petitioner / joint petitioner A. So that would be where John pays Jane. And since Jane is the one filling this out, I suspect typically what we see is that the person filling it out usually doesn't say, oh yeah, I need to pay the other person. They usually are requesting a payment to them. So we'll say Jane is the same way, and she's saying John should make a payment to her. And then here you're going to indicate if the payment has been made, you'll check 1. So if John already sent her a check for $2,000 and they're good, she'll check 1, has been made. If not, and sorry, it sounds like whoever's above my office here is thundering around a little, so sorry if you guys are hearing that in the background. But anyway, if it's been made, she'll check number 1. If it hasn't been made, then you will check you can either check number 2. Number 2 is saying that John should pay this whole $2,000 lump sum. So if he's got $2,000 in a bank account, basically he has to pay that whole amount no later than. So we're going to put a deadline here. So again, most of the time for my examples, they've been giving him a few months. So we'll put that in. It can be any date you want, although obviously keep in mind if the deadline that you put is before your hearing. So right now it's November of 2020. If I put, say, December 1 of 2020, my court date won't be before then. Here in Milwaukee, it usually takes a couple of months to get into court at least. So, 2 or 3 months. So if John doesn't make the payment, until this becomes an order, I don't have an enforcement mechanism. So you can put whatever date you want, but just be aware, until the court actually orders it, you can't use this document to force the other person to pay. So we've got that. The other option is if John can't make a lump sum payment, then what Jane could say is he'll pay per month. So he's got to pay her $2,000. She might say he can pay me $50 per month beginning in, again, we'll say, June 6th or June 1st of next year, and he'll continue until it's all paid off. So you'll pick whichever of those works best for you. Last but not least, you'll indicate whether the amount is going to earn any interest. If it's not going to earn interest, you'll just put a 0 here. If you want it to earn interest, you'll propose whatever amount you think it should be as far as earning interest. And then you'll indicate if you are asking for interest, whether it should be calculated from the date of the final hearing or whether it should be calculated from the date the payment was due. So that would be like, let's say John was supposed to start paying 6/1. He didn't. Does the interest start as of the day he doesn't pay it, or does it start as of the date of our final hearing? So we'll say that they're going to calculate it from the final hearing. All right, next we have the taxes section. So here you're going to indicate if you have already filed all tax returns for previous tax years. If you have, you and your spouse, as far as you know, have filed all tax returns for previous tax years, you'll check A, and you're done with that section. If either you have some outstanding taxes that still need to be filed, or the other person does, you'll check B. And then if you plan to share the expenses, so if you hire H&R Block to do them, that expense, the liability if there is one, or the refund, you'll check 1. Otherwise, if you plan to do it some other way, you can do it under other. A lot of folks will say file separately, and then, like each responsible for own expenses, and then liability/refund, or what have you, or whatever you're agreeing to here. One other situation we see from time to time is, let's say for some reason you're not required to file taxes. You didn't make enough money last year, or your only income is, Social Security or disability or something where you're under the threshold where you need to pay taxes. You're not making enough money that you're required to file. Then you have a few options. Some folks read this to say, have you filed all tax returns that you plan to file? And so they say, well, I don't plan to file, so I can say A, all tax returns for previous years are dealt with. That's the way some people approach it. Some people say, well, that makes me uncomfortable because I didn't actually file and I don't want to misrepresent that to the court. So they'll check B, and then they'll check 2, and they'll say, petitioner not required to file for, 2019 and through 2020 or whatever. So that's another option. You can do whichever of those suits you best. But we'll say in our situation that John and Jane have filed all the taxes that they need to, so they're going to be under A. And then last but not least, we have the legal name restoration section. So legal name restoration is used if anyone has changed their name. So if Jane took John's name, so I know we've been calling her Jane Doe, but if she'd been instead Jane Smith, so she took her spouse's name, or if she knows so maybe she goes by Jane Doe, she never changed her driver's license, but she changed her social security card, or, changed something over to her married name. That's sort of the situation this is addressing. And it can be either party. It doesn't have to be the female party. It is more common, at least as I'm recording this right now, for women to change their names, which is why I'm using Jane as my example. But if John had changed his name, if he hyphenated or something, you could also change John's. So anyway, if neither of them changed their name, you would check 1. Or if somebody changed their name but knows for certain that they don't want to go back to their former surname now or ever in the future. So let's say, Jane really hated her maiden name and she never, ever, ever wants to go back to it. Then they could say neither party is requesting the right to go back to a former surname. If Jane wants to go back to her maiden name or any other last name that she's ever used before, Because remember, Jane is our petitioner, joint petitioner A. So our petitioner, joint petitioner A, if you want to go back to a name, you'll check 2, and you're just going to indicate what that name is that they'd be going back to. Do note that this gives you the right to use a former surname, but it doesn't force you to. So if you're someone who thinks you might want to go back to your former surname sometime in the future, even if it's going to be 20 years from now when your kids graduate college, you still can check 2 or 3 and put the name you'd like to go back to. Another question we commonly get from folks is, what if I want to force the other person to change their name? Unfortunately, there isn't a mechanism to do that. So if, let's say Jane had taken John's name and he says, I really don't want her to have my name anymore, I want her to go back to her maiden name. He can't force her to. He can make it as easy as possible for her to change, so he can check here and say she has the right to go back to that former surname, so now she only has to take her order to go change it. But there's no way to make her change that name. And then obviously if you are the respondent or joint petitioner B and you're wanting to change your name, you check 3, and then you write in the name you'd like to go back to. And it does have to be a former surname, so a last name you have used in the past. And then one last thing just to note on the last name restoration. The court can't order a last name to be restored in a legal separation. So if you're requesting a legal separation, they can't order it until or unless your legal separation is converted to a divorce. All right, well, that is all for these sections. Thank you, as always, for watching this video. If you have any questions, you can definitely come into the Milwaukee Justice Center, located in room G9 of the Milwaukee County Courthouse. At least during non-pandemic times, that's where we are. So thank you all for watching, and I hope that in the meantime, you all go out and represent yourselves well.